stayed. It means that you probably, and your decision is taken to the higher court and the case is stayed, it means that you would have to stay your hand until the matter is determined. Another thing is also that we need to be able to look at the procedures, timelines for filing pleadings, from the stage of filing a writ of summons to the stage of filing your pleadings to the application for direction stage. Is it possible to shorten the process so that we can expedite the cases? That is what I'll say for now. Thank you very much, Honorable Chair.
Now, from your answer on procedure and processes, are you then suggesting that the rules of court are too complex? It's been argued by some people that the rules of court are too complex for ordinary Ghanaians who do not have legal representation. Would you recommend that the rules of court are made very simple, very basic for everybody to understand so as to help expedite the way and manner cases progress in court?
Thank you, Honorable Chair. For me, it's not the complexity of the rules of court, but the timelines may have to be looked at. Because if you have to file a writ of summons and statements of claim, and it will take you about 22 days for the other party to file a defense, we may have to look at it and see if we can shorten the timelines to be able to expedite the filing of pleadings. In that case, we could speedily resolve these disputes. So for me, it's not the complexity, but the timelines. Thank you, Honorable Chair.
My second question, I was trying to do some academic exercise on my own this morning, playing the devil's advocate at the same time. I looked at the CI-47, particularly Order 1, Rule 2. Then I asked myself if all the other orders following after Order 1, Rule 2 help promote the aims and objective of the CI-47 as contained in Order 1, Rule 2. Order 1, Rule 1, 2, yes.
Well, my recollection of Order 1, Rule 1, 2 enjoins the court to ensure that matters are speedily and effectively determined. But since the rules guide the court is guided by the rules in determining these matters. And as I have already said, the Rules of Court Committee may have to look at the timelines for filing of pleadings until when the pleadings are closed and the trial actually starts after applications for direction stage. So I think that timelines may be considered. Thank you, Honorable.
Post-application for direction.
My lady, my next question is, don't you think that the problem has to do with post-directions, the procedure where there are no timelines? Is that not where the problem is, where that is subject to the discretion of the court?
Honorable Chair, can I have a clarification of the question? I don't seem to.
But what I'm saying is that after the application for direction stage, there are no clear timelines. Yes, as to when trial should commence. Is that not where the problem is?
We can have timelines for completing trials, but as I indicated earlier, that would also depend on the number of cases that a court has. Because if a court has 300 cases and 100 of the cases are ripe for trial, definitely some would have to abide other cases. And that is when you are going to have a backlog of cases. So if we are going to have timelines for trial of cases, then we have to address the issue of the number of cases per judge. Then we can give effective timelines for determination of these cases. Thank you, Honorable Chair.
Thank you very much, my lady. My last question, third and last question. Your sister, my lady Janapari, was here yesterday, and as an answer to a question on the activities of the legal aid, she suggested that young lawyers being called to the bar must be made to do some service over there to help reduce the burden on the ordinary Ghanaian who cannot pay for legal service. Do you agree with that?
Thank you, Honorable Chair. I think it's a good suggestion. But I would also say that if the Bar Association does not already do so, the Bar Association should encourage every lawyer to do some amount of pro bono work. I think this will go a long way to assisting with the problem. Thank you, Honorable Chair.
I'm very grateful, my lady. I believe every lawyer does pro bono. I mean, the chairman would agree with me. Even in matters where you charge a fee, sometimes when you are done, they refuse to pay. So that's pro bono.
But there is a remedy available for you to recover your fees. You have a remedy under the law to recover your fees. Thank you very much. I will then proceed to give the floor to yes, Alhaji Omar.
Thank you, Chairman. Congratulations, my Lordship. Happy Sata Amalaba. I'm so happy to see you, and looking at your CV and your background, I'm happy because it gives hope to our daughters and our sisters from the region where we come from.
Thank you, Honorable Chair.
My question to you this morning is, what do you hope or want to be remembered for as a justice of the Supreme Court of Ghana?
Thank you, Honorable Chair. I want to be remembered as a hard-working judge, one with integrity, an assiduous judge, and one who sets precedent that will stand the test of time. Thank you, Honorable Chair.
Thank you. The second question, I want to find out from you your belief in the interpretation or the what? I have some cold. The doctrine of separation of powers.
Thank you, Honorable Chair. Now, the various arms of government, the executive, the judiciary, the legislature, are all independent. But they have to be interdependent as well to ensure that we have cohesive administration of governance. And so we would have a situation where Parliament would approve the budget of the judiciary. And we have a situation where in the Supreme Court's exclusive in the Supreme Court's exercise of its exclusive original jurisdiction, it can have oversight responsibility or review, what is called, informally called the judicial review powers of the Supreme Court, to determine whether Parliament or the executive are acting in accordance with the Constitution. So even though they are independent, they cannot be separate because we are running a governance system. And so they must work together to be cohesive. Thank you, Honorable Chair.
Thank you, and I wish you well.
Thank you very much.
I'll give the floor to Elec Blima.
Thank you, my lord, my lady. Langwane.
Lanson.
Great. I saw the name Amala Bowman. So, no, I'm not sure she's a Fafra. Yeah, thank you and congratulations.
Thank you.
Yes, I went through your CV and I'm interested in the works you did concerning in relation to divorce marriage, because I had my MPhil in marriage and counseling. And once a while, cases come, and most of them, the reason why they want to divorce or separation, they want separation, is lack of commitment from the man. Yesterday, I asked a question with one of the judges. Do you think introducing child support in Ghana would help bring down cases of divorce in our country?
Honorable Chair, may I seek a clarification of the question? Child support as in maintenance?
Yes, maintenance.
Very well.
Because it happens in the other world, yes, after divorce.
Sorry. Thank you, Honorable Chair. We have child support in Ghana. And so in the court, you can bring an application to the court for maintenance of a child. In fact, under the Matrimonial Causes Act, you can bring a petition for maintenance without bringing a petition for dissolution of marriage. But when you bring a petition for dissolution of marriage, you can also seek orders for child support, which we call maintenance in this country. And the court will consider it. The court will consider the best interest of the child and make an award looking at the circumstances of the case and the means of the person involved. So we do have child support in Ghana. Thank you, Honorable Chair.
Thank you, Mr. Chair. My second question, can you take us through the process of adoption in Ghana? Because once a while, just as I said, I have issues coming up where couples have been married for some time now and there are no issues, and they don't know the process of getting adoption in Ghana especially.
So, Honorable Akurugu, you don't want the bar to prosper. The bar must prosper. My lady, you may proceed to answer.
Thank you very much, Honorable Chair. The process of adoption starts from the Social Welfare Department. First of all, you must contact the Social Welfare Department, and then they would assess your needs, the kind of child you want, and then see if they have children available, and they would make the necessary recommendation. Now, when the application is brought to the court would look at the application, the court would look at the circumstances of the child and decide whether it is in the best interest of the child that the adoption be granted. But now we have a central adoption agency, just so that adoptions can be streamlined to meet international standards. And so the Central Adoption Agency, which ordinarily is under the supervision of the ministry, would ordinarily approve for you to adopt the child. And then you bring an application to the court, and the court would look at the application and decide. The fact that the Central Adoption Agency has approved does not necessarily mean that the court would approve. The court, if it approves, will grant the application for adoption.
That's for it, Mr. Chair. Congratulations once again.
Thank you very
I'm
much.
wishing you all the best.
Thank you.
Well, I proceed to recognize Honorable Tampuli.
Thank you very much, Mr. Chair. Mr. Chairman, the gentleman sitting behind the nominee, Mr. Peter, is my very good friend. So I'm thinking if I even ask a question, I will be asking him indirectly. Nevertheless, my lady, I congratulate you on your nomination.
Thank you very much.
There is something that I've noticed about the judiciary, especially Superior Court judges, which is the fact that you have a number of judges being chiefs in addition to being judges. Now, under the 1992 Constitution, and if you read Article 78, one's legitimacy can be questioned. Why should chiefs continue to, serve on the judiciary? I thank you, my lady.
Thank you very much, Honorable Chair. The chiefs on the judiciary serve as chiefs with the permission of the Judicial Council. I believe that because the Constitution wants to ensure that chieftaincy is insulated from politics, that is why members of parliament are not supposed to be chiefs, because the chiefs are supposed to be neutral, so to speak. And so if you become a politician and you want to become a chief, it would seem to me that the institution would be politicized. That probably is the reason why the Constitution does not permit it. Thank you, Honorable Chair.
Mr. Chairman, a follow-up. My lady, will your answer be different if you find instances where chiefs who are also judges meet political heads, candidates, and they start talking, yes, Taiwuchi, we are with you, we'll make sure you win, and so on and so forth. Appearing before that judge, with that sense of neutrality still be there. I mean, the cloak would have been taken off him for the comments, some of these comments. Meanwhile, the chief probably is just looking for development for his people, but his comments, may be taken as a very weighty matter, which would take him to the side of politics and remove the neutrality cover.
Thank you, Honorable Chair. I believe that as a judge and a chief, you ought to be measured in your commentary on politics, especially in support of one group or the other. So I believe that the judges are able or should be able to be measured in their language. Thank you very much, Chair.
It's now the turn of Honorable Haji Aladi Ayamba.
Thank you, Chairman. My sister Amal Boba. Lahotuma, tuma, humoya. Well done, you've done well.
Thank you very much, Honorable Chair.
There is the issue of whether or not to cap the number of Supreme Court judges. Currently, according to information, we have 13. If 7 of you go in, and inshallah you will be 20. What is your suggestion about the numbers? Should we add up, just leave the law like that, continue to add up, or we should cap it?
Thank you, Honorable Chair. I believe in capping the number of Supreme Court judges, but I believe that we should not hasten to do so until we have resolved the issues that confront the Supreme Court, which require that the numbers be increased. Because if we cap it and there is a justification for an increase, it would mean that we would subject our Constitution to constant amendments, and that will not be desirable. But if we are able to solve the problems at the Supreme Court, the backlogs, the various jurisdictions that it has, then we would have a fair idea of how many cases on a year-by-year basis would go to the Supreme Court. And then we can have enough reason or basis to cap the numbers. Thank you, Honorable Chair.
Chairman, my second question. My second question has to do with Article 142 of our Constitution. Members who may or may not be lawyers. Do you subscribe to our having regional tribunals? And if the Chief Justice is supposed to be part of the panel there or the team there that is going to work, how do we get enough of such people at any given time so that it shouldn't be like, oh, the Chief Justice hasn't come, so we do not know what to do. Let us postpone the case, let us hold on, and maybe when she's ready or when he's ready, then the case will be heard, where our cases will be prolonged.
Thank you very much, Honorable Chair. I do not know the policy rationale for why the tribunals, the regional tribunals, were abolished, so to speak, or were subsumed into the regular court system. But it still remains part of our law. And the law says that it is the duty of the Chief Justice to establish regional tribunals, and the duty of Parliament to prescribe exactly what their jurisdiction should be. Regional tribunals still remain part of our laws. I do not have any aversion to regional tribunals. I would also like to say that the Chief Justice is a judge of every court in Ghana. The Chief Justice is the first judge of every court in Ghana, but she does not sit when it's empaneled, even though she can decide to sit. So ordinarily, a 3-member tribunal doing its work would not require the presence of the Chief Justice to sit. Thank you, Honorable Chair.
Thank you, Chairman. I'm most grateful. I wish you all the best.
Thank you very much.
Thank you. I'll give the floor to Honorable Bit Zidin, Awantazuma.
Thank you very much, Honorable Chairman. Your Ladyship, congratulations for the nomination.
Thank you very much, Honorable Chair.
And let me tell you that we, the Upper Westerners, we are very proud of you.
Thank you.
I made this statement when His Lordship, Surbare, appeared before us. And I indicated that we are happy to have 2 Supreme Court judges coming from the Upper West region, because you will be approved.
Inshallah.
And we are further proud of you because we have the first lady Chief Justice also coming from Upper West. We hope that in course of time, our colleagues in the other northern regions will also benefit from this exercise. Anyway, ordinarily, I should not be asking you any questions, but I'll just ask you one question. But even before the question, some small comment. You are a Christian, but it's surprising that your first name appears to be a Muslim name. I'm curious about that. I will not expect any response from you, but it is interesting that you are a Christian and yet you have a Muslim name. I believe that the second name is your husband's name, and your husband must be one of our playmates. So it is all good. Mr. Chairman, you are not happy, eh? The way you are looking at me.
Yes, because you are to ask questions.
Yes. I'm coming
You
to
are
the
not to
question, Mr.
run
Chairman.
commentary.
Mr. Chairman.
And you know you are violating the rules
Yes.
of the House.
Sometimes.
So you don't expect me to be happy when you are violating the rules.
Thank you very much, Mr. Chairman. The question is, the retiring age of public servants in this country is 60. Sometimes it is extended to 60, a maximum of 65, 61, 62, 63, but maximum of 65. But justices of the Supreme Court, they retire at 70. So it appears there is some discrimination because these categories of people are all serving the Republic. Your leadership, in your view, is there justification for the difference? Other public servants retire at 65 maximum. Judges retire at 70. Is there any justification for this difference? Thank you.
Thank you, Honorable Chair. The justification that I see is that in the administration of justice, we need qualified, experienced jurists to be able to adjudicate matters that will stand the test of time and to be able to also guide relatively younger judges on how to proceed. So we need experienced jurists in the Supreme Court because that is our final appellate court. It is also our constitutional court, and it has various other jurisdictions. So I believe that the age is important because of the experience and qualifications that the jurists would have gathered over the years. Thank you very much, Honorable Chair.
Mr. Chairman, that will be all for now. Thank you. And I wish you very well.
Thank you very much, Honorable Bid. Yes, Patrick Yaboma.
Thank you, Chairman, and congratulations, my lady. Thank you. My lady, I've gone to your CV, and I've realized that you've chaired quite a number of committees aimed at reforming the judiciary, or the judicial service. Committee to investigate allegations of procurement of fraudulent divorce certificates and other court documents, 2023. Committee for setting up attestation units in other regions and for digitalization of the said units, 2023. Committee for implementation of recommendations made by the committee to investigate allegations of procurement of fraudulent divorce certificates and other documents, 2024 to date, and a host of other committees. I would want to know from you how the implementation process has gone on with regards to some of these committees that you've chaired, and remedies they seek to achieve in advancing our judicial process and also promoting the integrity of the courts. Thank you.
Thank you very much, Honorable Chair. In respect of the procurement of fraudulent documents and the attestation units, these two are linked. So it is the aim of the Judicial Service to ensure that people do not procure fraudulent divorce certificates and documents and parade them as coming from within the Judicial Service. So what has happened so far is that we intend to start a process. We are just at the implementation stage. We intend to start a process of ensuring that divorce certificates have special features and that special seals are given to judges, and also electronic signatures are used for these documents. We also intend to ensure that each certificate would have a barcode, so that if you have a smartphone, you can scan the code, and that will tell you whether or not the certificates or the document is coming from within the judicial service. Now, with the attestation unit, we are yet to start work on the attestation unit. And the intention is to digitalize the attestation unit to ensure that all attestations are done through a system electronically, so that we take out the manual attestations, which can be forged by people outside of the service. But if we have all of them passing through the system, then it's easy to track and ensure that we don't have forged documents out there. But with the attestation unit, what has started happening is that if you take a document to the attestation unit for attestation, your ID card would be taken and a photocopy would be made of it. Now, and documented, if it is realized that the document is a forged document, you will be reported to the police and you will be arrested. So that is how we have started working in respect of these committees. Thank you very much, Honorable Chair.
Chair, and a follow-up, and are you receiving the needed funding to ensure the actualization of this project, and from where?
We have not yet requested for the funding. For now, the attestation unit is using the resources it has at its disposal to ensure that this is done. But we will get to that stage where all of the various departments involved will come together, the budgets will be drawn, and then the necessary things will be done. Thank you very much.
Chairman, I'll go to my seconds around the table. We politicians, those of us here, we tend to play politics with a lot of things. When it comes to the appointment of judges, independent constitutional officers, we talk a lot. You read our Hansard, the debate, so partisan in nature. In 2022, you got the opportunity to be nominated to sit on the Court of Appeal. Some justices sat at the High Court, straight to Supreme Court. Some 1 year at the Court of Appeal, straight to Supreme Court. Some became Chief Justices and what have you. I believe when you go to the Court of Appeal, you met some senior members too there. And by God's grace, you've gotten the opportunity to be nominated. What would be your advice to those of us around the table that nominations are not political, but based on certain steps or considerations? And that's one of the reasons why you are before us. So what do you have to say to some of this things? You see you politicians.
Honorable Chair, I would pray to let the cup of advising the politicians pass from me. But what I would say is that, indeed, I met some judges at the Court of Appeal, and I have a lot of respect for my esteemed colleagues on the Court of Appeal bench. Nominating a judge for the position of the Supreme Court is the prerogative of the President. And the President has done so. And I believe that I'm qualified. I have spent 15.5 years in private practice. I've spent 11 years on the bench. I'm 26 years at the bar. I am qualified in accordance with the constitutional requirements. I'm capable, I'm competent, and able to discharge the duties of a Supreme Court judge. Thank you, Honorable Chair.
Thank you very much, my lady. and I know you distinguish yourself and put to rest some of the debates some of our colleagues wage. Lady, can we look at the rules of fair trial, I think Article 19. It deals with a lot of issues when it comes to fair trial and what an accused person ought to be, the opportunities that accused person ought to be given, right to counsel, facilities, what have you. And reading that in conjunction with I think Section 967 of Act 30 on bail. Sometimes bail conditions are a bit too onerous that a lay person can easily say that this will amount to being denying the person bail or it amounting to punishing the accused person. It's a discretion given the judge, given the circumstances or the facts before the judge. How would you explain some of these factors to the listening public as to what goes into the grant or some of the bail conditions that you give to accused persons, in order not for the public to think the accused person is being punished or being denied bail? Because I recall some comments by the late Justice Badigbe that some of the conditions may amount to punishing the accused person. I want to hear your thoughts on the rules of fair trial and bail conditions, which some of us deem too onerous. In our opinions. Thank you.
Thank you very much, Honorable Chair. Well, the position of the law is that all offences now are bailable. And if an accused person is granted bail conditions, which he or she deems are onerous, you have the liberty to apply for a variation of your bail conditions. And if you find a stumbling block in that court, you can appeal against those conditions. Because the aim of the conditions is not to punish the person, but to ensure that you will make yourself available for trial. And that at the end of the day, if you should abscond, the sureties who have signed your bond would be able to meet whatever conditions are required of them. And so it is not supposed to be a punishment. So if you are unable to secure bail or the conditions are onerous, you either apply for a variation or you appeal so that the appellate court can take another look at it. Thank you very much, Honorable Chair.
Thank you, my lady. It will surprise you that you appear before a judge and the mood of the judge will be that, oh, yes, I've refused your application. You can go up. Straight away. And without considering the merits of the application, say, oh, okay, I've read and I'm refusing, you can go up. And you can easily tell from the court that the person wasn't minded to even listen to you or take into account the conditions that the judge was setting. And it becomes problematic because I was in court one day, the accused person had served his term, it was left with only 3 months, and the lawyer was making an application for for a variation of a certain order that the judge had made. He said, oh, no, I'm refusing it. You can go on appeal. The person was left with only 3 months, and was within the judge's remit to consider the application before her. And it became some banter between the lawyer and the judge in open court. And those are some of the things that I believe that when you go for training, you can look into some of this. The temperament at the bench sometimes makes lawyers exchange, for want of a better word. Thank you very much, my lady.
Thank you very much, Honorable Chair. I believe that the JTI would take that into consideration and ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best, and God bless you.
Thank you very much. Honorable Jerry, you have the floor.
Thank you very much, Honorable Chair. Honorable nominee, congratulations on your welcome. Lady, you've been in this practice for 26 years, and you've dealt largely with issues of dissolution of marriages. Lady, family law cases increasingly involve complex constitutional questions regarding gender equality, children's rights, and traditional versus modern family structures. Given your very extensive experience in family law, how do you view the Supreme Court's role in balancing traditional family structures with evolving constitutional principles of gender equality?
Honorable Chair, can the question be clarified?
The question is seeking to know how you intend to use your background as an expert in family law to deal with issues of constitutional matters, especially people are now making more or concentrating their attention on gender equality. How do you marry the two? How are you bringing your rich experience on family law to deal with issues of gender equality?
Thank you, Honorable Chair. When it comes to family law, the principles are applicable equally to men as it does to women. Because when it comes to distribution of marital property, it is not based on gender, even though it may seem so. It may seem so, but the law is not based on gender. Because it says, Article 22 says that assets acquired jointly during marriage are to be distributed equitably. And whether, irrespective of their gender, that is what the provision is. So it is not in any way discriminatory of any gender. That is my answer to the question.
Just a follow-up. Have you handled cases where the man seemed not to have properties, but the woman seemed to have properties, but they had these properties during the currency of the marriage, and then when it came to distribution, there were issues because the man was now requesting that the properties be shared equally?
I do recall that there was a case before me where the man did not have properties, but the woman did. And I gave the man part of the woman's properties. The man did not have properties, but the woman had properties. And the man was entitled to a share in the woman's properties. And that is exactly what I did. Thank you very much.
Thank you very much, Milady. Milady, the Supreme Court frequently addresses cases involving children's welfare that require balancing parental rights, state intervention, and the best interest of the child. Lady, how can the Supreme Court interpret constitutional provisions regarding children's rights when they conflict with this parental authority or cultural practices?
Thank you, Honorable Chair. The law is clear that in every matter affecting children, the welfare of the child is the court's primary consideration. So in all matters affecting children, it is the welfare of the child that is the primary consideration. So that is what the law says, and that is what is applied in the courts. Thank you, Honorable Chair.
Lady, have you had the occasion of dealing with a matter that the welfare of the child, although very key, the Constitution perhaps also had a position, and therefore you felt a bit conflicted, and especially as a mother?
Can I have a clarification of the constitutional conflicts? I'm not too clear on the conflicts. Thank you.
Well, maybe there was a set, like you just gave a response, and then there was the basis for you to proceed to say that, well, the law is the law, and so I need to proceed to give a judgment or make a decision or a determination based on the law. But you also felt that at this point in time, maybe you could have considered the child's welfare more, but it still conflicted with the law, and therefore you proceeded to deal with the matter the way you had to deal with based on the law.
What I said was this, that where a child's welfare is in conflict with a parental authority, you said, then in that case, the child's welfare will be considered. Because in considering the child's welfare, you must find out whether or not what the authority the parent seeks to exercise is in conflict with the rights of the child. And if it is in conflict with the rights of the child, then you need to prioritize the welfare of the child. That was what my explanation was.
Well, I think it's well understood. Lady, this will be my last question. Is how do you envision the Supreme Court's role in developing constitutional standards for ADR, alternative dispute resolution mechanism?
Thank you very much, Honorable Chair. The ADR Act is the standard for resolution of disputes by either mediation or arbitration. And I believe that this is what is enforceable, even in the Supreme Court. If the matter should probably go to the Supreme Court, but not on the merits, because you cannot appeal against an arbitral award, for instance. You can only seek to set it aside on procedural or other grounds, but not on its merits. There's no appeal in respect of that.
Are there any recommendations you would want to make in reference to ADR, the ADR mechanism?
Not immediate. I can't think of any immediately. Yes.
Well, my lady, I wish you all the best, and congratulations once again.
You're done, Honorable Chair. All right, I will now call on Honorable Lefiamapo. You have the floor, Chief Whip.
Mr. Chairman, thank you very much. My lady JS is soon to be. You are welcome, and congratulations. During our formative years at the bar, you were one of the few lawyers that anytime you step into court, we had to wait to listen to you. And then when you got elevated onto the bench, we had tough time before you. So you didn't get here by accident. You merited it. And I'm very proud of what you have achieved so far.
Thank you, Honorable Chair.
I have two questions by way of policy, and so I'll zoom straight into the first one. One of the jurisdictions of the Supreme Court, by way of appellate jurisdiction, is to hear matters emanating from the National House of Chiefs when an aggrieved party, after exhausting the procedure there, proceeds to the Supreme Court. Now, in Articles 270, 271, and 273, speaks of the Chieftancy institution and the National House of Chiefs and the Regional House of Chiefs. Now, in the Constitution, there is a provision for lawyers to assist the judicial committees when they are determining chieftancy issues. The National House is to be assisted by a lawyer of not less than 10 years. The regional ones, a lawyer of not less than 5 years. We didn't make any such provision for the traditional councils, the judicial committee of the traditional councils, but we borrowed the spirit and letter of the Constitution and inserted it in the Chieftancy Act. But the arrangement creates a problem because, I'll set the question, it's a background. The matters that eventually will come before you at the Supreme Court emanates from the judicial committees of the traditional councils. And there we ask lawyers of less than a year or not at least 1 year to assist them. So where error occurs, it then travels all the way to you up there. I know it's this house that must make amends. So will you support a proposal that instead of the lawyers assisting, they are made to participate in the proceedings by being part of the panel instead of being made to assist? And because in most cases, I've done, by way of work, we've done some chieftancy cases, and the traditional councils don't have money to hire lawyers. So it's the chiefs who go on and handle the matters, riddled with errors. It gets to the region. Some too don't have resources to engage lawyers. So it's the national that really have some lawyers assisting, by which time the damage would have been done.
Thank you, Honorable Chair. I believe it's a laudable suggestion and one that I would support. And invariably, it would also reduce the workload at the Supreme Court. Thank you very much, Honorable Chair.
Great. My other concern is in respect of the matters containing Article 153 and 154, the Judicial Council.
Sorry, Leader. Is this a follow-up or is it a new question?
Chair, I was very clear that I have two questions. Yeah. The first one is done. Okay. So the second one is in respect of the Judicial Council, creature of the Constitution.
Go ahead.
If you look at the composition presently, a very key stakeholder in the justice administration and delivery channel is not included, which is the Ghana Prison Service. Again, would you support the proposition that we should have a representation of the Ghana Prison Service as part of the constitutional amendments, represented on the Judicial Council?
Thank you very much, Honorable Chair.
Especially in view of your functions, in view of the functions that the Judicial Council performs.
Thank you very much, Honorable Chair. I believe it's a good proposal because it would seem to me that the prison service is an important stakeholder in the administration of justice. Thank you.
Chairman, thank you. Let me once more congratulate you, and we wish you all the best. And we'll look forward to appearing before you in the future.
Thank you very much.
Congratulations.
Thank you.
Thank you very much. It's the turn of Honorable Patricia PJ. You are Deputy Ranking. You are on the floor.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to take this opportunity to congratulate our lady. And I'm actually ceding my time in order for you to live here. And I'm ceding my time to the minority leader to go through. Thank you very much.
Thank you, Honorable Chair.
Thank you very much. I will now cede the floor to Osahini.
Who is that?
The ranking member. Thank you.
Thank you, Chairman.
Please go ahead. Please go ahead. Minority
Chairman,
leader, please go ahead.
I just heard that you are going to call the majority leader after I'm done for re-examination. Then you call him. He, as a leader, is entitled to be here. Call him. The practice and the protocols which he knows is that I'm the last. I'm your ranking. I'm the last to ask. So you, if he wants to ask, let's allow him to ask his questions.
Honorable ranking member, at the moment, I am the chairman of this committee, and I'm the last person.
Hello there. I want to invite you to the 2025 edition of the Ghana Feminine Achievers Award, happening on the 27th of June at the Accra International Conference Center.
At least.
In the Western region. In the Western region.
Very well. My lady, please, in your time after doing your national service, are you issued with a certificate during those periods? Were you being issued with certificates?
I did not get a certificate. I did not get a certificate when I finished. I am sure I could have applied for a certificate, but I did not get a certificate, yes.
The reason I ask you, in all fairness, is because national security got back to us that they have no such records of you having done your national service at Kangunli JHS in Western Region. That's why I wanted you to clarify, because
I did.
Very well. So you may have to furnish us with some other details you have later, not now, just to confirm. All right. Now, what is your age now, please?
I'm 52 years old. 52 years old.
Very well. So what it means is that if the opportunity avails itself, you would have some 18 years to serve on the bench.
That's correct.
My lady, I intend to take your thoughts on Articles 286 and 287 of the Constitution. I would preamble what I'm going to say with His Excellency the President regarding imposition of salary fines on ministers and appointees who fail to declare their assets. I shall also want to know your mind on the exclusive role of SHRAJ in investigating breaches of asset declaration obligations. That said, as a background, I proceed to ask you, one, in your view, do you think that the president has a constitutional authority to impose sanctions, such as fines on ministers and other appointees who fail to declare their assets? Or, to you, this function is exclusively reserved for SHRAJ under Article 287 of the Constitution?